This High Court of Australia case discusses the fundamental distinction between a question of fact and a question of law. South Australia once had a system of rent control which stopped household rents from rising too high. At the end of 1962, that legislation expired, but determinations made under the expired legislation continued. The defendant in this case owned a rent-controlled semi-detached home. A level of rent had been determined under the legislation, and that level of rent remained the limit, even after the legislation expired. He didn't realise this, and he lifted the rent. He was charged with breaching the repealed legislation. He won in the High Court on an unrelated technical ground, but the judges also explored the distinction between a question of fact and a question of law. As always on this issue, the judges had slightly different views. Justice Windeyer gave the most detailed discussion. For him, the distinction between fact and law was not simple and could never be simple. He said, "The distinction between matters of fact and of law is of fundamental importance in English law. This is partly the result of the separate parts which judge and jury have played in trials at common law. The distinction which our law makes between law and fact, between questions of law and questions of fact, between mistakes of law and mistakes of fact, is by no means as easy as at first might be expected. That it is not absolute is illustrated by the many cases said to turn on a mixed question of law and fact. For Justice Taylor, the question was somewhat more simple. Ignorance of the law could not be allowed to become an excuse for disobeying the law. He said, "It cannot, in my view, be said that ignorance of the state of the general law operates to exonerate a person who has so acted as to expose himself to the sanctions of the criminal law, or that a mistaken belief that the law is such that his acts do not constitute an offence means that he did not do those acts wilfully." This case teaches us that the distinction between a question of fact and a question of law is crucial, because ignorance of the facts might provide an excuse, while ignorance of the law cannot. But distinguishing between facts and law is often subtle and not easy.